Hello, friends. Welcome to my channel. This is again Mercy. This is Lawyers Info Hub. I thank God for bringing us to a new year. I've done a video earlier in the year on how to position yourself to get the better part of 2021. But today I'm going to discuss on how to prepare a well-structured brief of argument. If you're a returning subscriber, I appreciate you. If you're new to this channel, please subscribe to this channel and share whatever I'm giving out here because I know it's full of knowledge, it's full of wisdom, and it's going to help someone out there. So, in preparing a brief of argument, it's a very important document process that is being used at the appellate court. Now, a good lawyer must know how to prepare a brief of argument. You know, appellate practice is a different ballgame, and for you to understand appellate practice, it means that you have stepped up to a level where someone can say this is a senior lawyer, or this one knows the law, or this one is well experienced in litigation. Now, we have different types of brief. We have the appellant brief, we have the respondent brief, we have the reply brief. Now, once the notice of appeal has been filed, time begins to run for the appellant. And the appellant must do all that is within his power to file before time, even though most times there are circumstances beyond the control of the appellant that makes the appellant not to file within time. But a good lawyer will always do things within time. Don't be a lawyer who's known for always bringing motion for extension of time, enlargement of time, so that you can put in the proper document. It's not really a good way to practice. Now, for you to have a good brief, there are features of a brief. There are things you need to see in a brief to say, wow, this is a good brief. Now, your brief must have an introduction. Be it the appellant brief, be it the respondent brief, must have an introduction. Even the reply brief must have an introduction. Now, after the introduction, this is where you explain that this appeal, arose from the decision of maybe the High Court of This or Court of Appeal sitting as so jurisdiction or division. Now, you have to also note the name of the judge who delivered the judgment if it's from the High Court. You have to also note down the names of the justices who delivered it if it's from the Court of Appeal going to Supreme Court. Now, you must also state the decision of that court which you are appealing against, which is for the appellant. You must state the decision of that court which that brought it to the Court of Appeal or the Supreme Court, depending on the circumstance. So when you state that, and you also state the judgment, that's the decision, and after you state the background facts. Now, the background fact, if it's coming from the High Court to the Court of Appeal, the background fact is the fact that maybe the appellant was the claimant or the defendant in the lower court. Okay, the appellant was the claimant or defendant in the lower court. He should take an action or file his defense and all of that. And at the end of the trial, called 3 witnesses, final written address was exchanged, and at the end of the day, the trial judge ruled or entered judgment in favor of the plaintiff or the claimant, depending on the jurisdiction. And you have to also list out what the judge or the lower court held in your background facts. Now, this is now the reason why you are here. You also state as the appellant that you have to also state the date of the judgment you are appealing against. Very important. state the date of the, then you state when the notice of appeal was filed. Also state that the notice of appeal either has 8 grounds or 3 grounds. You also state, very important. Now, if you know the date the record was transmitted, fine, but if you don't know it, you can also proceed. But background part should give a little history of your matter so that when someone is reading your brief, the person without even going through the record of appeal will be able to decipher what exactly this appeal is all about. So, a summary, a very well defined summary that is just straight to the point, what happened, what the court held, and the grounds of appeal that have been raised, and the grounds of appeal that have been raised, which will now formulate your issues of determination. Now, now in distilling your issues for determination, remember that as an appellant, the issues for determination must stem from the grounds of appeal, which is contained in your notice of appeal. Now, you must not raise an issue that is different or does have nothing to do with the grounds of appeal. Now, for every issue you raise or you distill, you must state whether it's ground 2 of your notice of appeal or ground 3. You can match three grounds and raise one issue for determination. You can merge 4 grounds and raise one issue for determination. But for every issue for determination which you raise, it must be linked to a ground of appeal. It's not at this point, you're not going to go outside what is contained in your notice of appeal. Now, we'll now look at the legal argument. Now, the legal argument is the part where you bring in the application of the law into what you're saying. This is where you appeal. This is where you appeal to the mind of the court, the appellate court, and let them see reason why they should tilt the hand of justice to your case or to your favor. This is where you bring in cases that are germane to the issues you have raised, and let them know why you think you deserve judgment in their court. This is when you distinguish cases. This is when you make your argument. This is the life of brief. You must make your argument to be succinct. You must make it to be convincing. Your argument must be convincing. Now, if you have a plenary point or a plenary objection, yes, you can also put it in your argument. That could be your first issue, but you have to put a heading so that you know that it's a plenary objection. So if you have a plenary objection, you can argue it first before you now enter into the other issues for determination. You know that your argument must be well arranged. Now, a good brief must be well numbered. It's not what you just do just like that. You have to be well numbered. The argument must be well numbered. You must make it sequential, so it to be understood. Your thoughts should flow. It should not be scattered. You must coordinate your thoughts, coordinate your argument for it to flow. Now, also a good brief will have list of authorities. This is the list of authorities you've started, list of statutes, list of textbook. For peradventure, you have made reference to the textbook. This is where you list all that. Now, what is the importance of a brief? Understanding the importance of a brief helps you to do all that is in your part to make a good research for your brief. Now, one of the actions of a brief of argument is to enhance speedy hearing of appeals. By the time sometimes when you see the bulky record, why would they have time to read all this and all that? But your brief is more like summarizing your it's more like summarizing your uh the record. Yes, in a short form, and it's also in oral submission. This is where you everything out, put it out, so that uh, you can get justice if you really deserve it. So it enhances speedy hearing of appeal, and it also reduces the time spent on oral adumbration or oral submission. Because at the end of the day, when you get to court, so that maybe you have 10 minutes, or depending if you're a senior lawyer, or sometimes you have 7 minutes, 5 minutes, 2 minutes to adumbrate. And if you have not written a good brief and you are relying on oral submission, sometimes you might not get it. So whatever you want to argue, whatever you want to say, let it be seen in your brief. Okay, very important is another very important factor you must consider when you're writing a brief is um, you must make reference to the record of appeal. Now, it's assumed that before you will write a brief, you must have read the record like 2 or 3 times, depending on your level of comprehension. Now, read the record, understand what the matter is all about, because sometimes you see that the lawyer that handled the matter at the lower court is different from the person that will handle it at the appellate court. Now, peradventure, you're just coming to you at the appellate level, so your understanding of the case begins by you reading the record, what happened, what were the processes that was filed, what was the line of argument, what was the decision of the lower court, what brought the appeal. So you must understand the record. Then in your argument, you must relate it to the record. When you leave something from the record, you must note, you must bracket, you must state it in your brief. Okay, see page 321 of the record. For everything you leave from the record, you must state it in your brief so that the justices will see exactly where you're referring to. You could say line 14 of page 312 of record of appeal. So you could just bracket it. So your brief should not just go without reference to the record of appeal. Very important. You must tie your argument, the facts, to the record. You cannot distinguish it. You cannot separate it. Your arguments must stem from the record, the facts of the case. So you must always make reference to the pages of the record where you're lifting your facts of what transpired at the lower court. Now, very importantly is the fact that your issues for determination should be presented in order of priority. Don't start with the weak argument. This is strategy. Don't start with the weak argument. Start with the very strong argument. Argue it first. Let's be forceful. Argue it first, then you not get to the last. So, well, sometimes I say no issue is small, but you know that maybe you're discussing the issue of jurisdiction. Maybe you're discussing on the issue of uh, where the court or maybe makes raises an issue so without allowing parties to address it on it. Start with jurisdiction. When you finish with jurisdiction, this is an example. You don't face the fact that in as much that the court has power to raise issues so much, but parties must be invited to address the court. Now stand to the next one. So you must be able to prioritize your issues and argue it in that sequence. Your brief must be legible. Yes, we're not presenting it in longhand, but after it's typed, don't use 10 fonts, use 14 fonts. It's also specified in the rules the kind of fonts you're going to use. But the essence is that for it to be legible, it should not be tiny, it should be very, very legible. Then that should be spaced to free before it is sent out for filing. Because sometimes you might have a wonderful argument written out, but the person that typed for you and must have made maybe one or two mistakes here and there. So you read your brief so that you can dot the I's and cross every T. And sometimes when you write a brief, it's important you give it to another lawyer to proofread for you. After you must have proofread it. Give it to another person because the person, please read this. It could be a colleague, it could be a friend. By the time the person goes through, the person might give you another idea. Or the person might say, okay, why not this issue comes before this? Or the person might help you correct some line of argument and put it well. So it is important the brief goes through at least one or two people before it is filed. That's why you have to start on time so that you can be able to allow other people to fill it before you file. Uh, then uh, I've always said that application of the relevant laws is very key. Your legal arguments, it will be very strong because it's going to stem from a good research. You cannot write prepare a good brief without proper research. There must be proper research. Proper research. You analyze the cases, you know, bring it to life. You say I've always heard the saying that if you see a good book, it will tell you whether the person reads law report or not. There's this saying that if a person who reads law reports understands the language of the court, and when he or she is writing the brief, it dictates those languages, and when the judge or when the justice sees like this one reads the law report, but I don't know how true it is, but you must undergo, you must prepare by undergoing a journey of research, bring out the relevant laws, and apply it to the issues you are going to argue. Remember, as an appellant, immediately the record of appeal has been transmitted. You have 45 days. You have 45, then you have 14 days to now file